meaning, meaning consumers now associate that specific descriptive term exclusively with your brand, but that's a high bar.
Secondary meaning.
Right.
Any other grounds?
Yeah, marks that are considered scandalous or deceptive or that misrepresent the goods or services, they won't be registered either.
Makes sense. Can't trademark common words or something misleading. Okay, what about businesses thinking bigger? Protecting a brand outside the U.S.
Good point. Our notes touch on international registration. There are ways to simplify this. The Madrid Protocol is a key one.
Madrid Protocol.
Yeah, it lets you file a single international application through WIPO, that's the World Intellectual Property Organization, to seek protection in multiple member countries. Much easier than filing separately everywhere.
That sounds useful.
And there's also the Paris Convention, which gives you a 6-month priority period. File in one member country, and you get 6 months to file in others while keeping your original filing date.
Handy for planning a global launch, maybe. Okay, so we've got the trademark registered. What comes after? What are the ongoing duties of a trademark owner?
Right. Post-registration is all about keeping that trademark valid and enforceable. As we said, that Section 8 affidavit of use between year 5 and 6 is crucial. Miss it, and your registration can be canceled.
Don't miss the deadline.
Definitely not. And the Section 9 renewal every 10 years is just as vital. Forget to renew, and the registration lapses. It's gone.
So keep using it, keep proving use, keep renewing. Anything else important after registration?
Yes, something called a Section 15 Declaration of Incontestability. It's optional.
Incontestability sounds powerful.
It is pretty helpful. You can file it after your mark has been in continuous use for 5 straight years. It doesn't make it bulletproof, but it significantly strengthens your legal position. It makes it much harder for others to challenge the validity of your trademark on certain grounds, like arguing it wasn't distinctive enough to begin with.
Like extra legal armor for your brand.
That's a good way to put it. Beyond these filings, though, trademark owners need to be proactive.
Proactive how?
Monitoring the marketplace. Looking for anyone using your mark or something confusingly similar without permission.
How do you even do that?
You can do searches yourself or use specialized trademark watching services. They can automate it.
And if you find something?
Then you need to act. It might start with a cease and desist letter.
Asking them to stop.
Right. Or it could escalate to a lawsuit if necessary. And for physical goods, remember, you can record your trademark with Customs and Border Protection CBP. That helps them stop counterfeits at the border.
Ah, using CBP. Smart. So it's an active defense job. Now, what could actually cause you to lose your trademark rights even after you've registered and maintained it?
2 big dangers. Genericide and abandonment.
Genericide. Sounds ominous.
It is, for a brand. It happens when your trademark becomes the common everyday term for that type of product or service. Think aspirin or escalator, those used to be brand names.
Wow. So how do you stop that?
Correct usage is key. Always use it as an adjective, not a noun, like Kleenex brand tissues, not hand me a Kleenex. Use the E or a symbol. Educate people on how to use your brand name properly.
Got it. Use it as an adjective. What was the other one? Abandonment.
Yes. Abandonment happens if you stop using your trademark in commerce for typically 3 consecutive years and you don't intend to start using it again. It's crucial to keep records showing you are still using it commercially.
So use it or lose it, basically. Genericide and abandonment, things to watch out for. Okay, let's shift gears. What if a business wants to, say, sell its trademark or let someone else use it? Can they just hand it over?
Not quite that simple. There are 2 main legal ways: assignment and licensing.
Assignment and licensing, what's the difference?
Assignment is a complete transfer of ownership. You sell it, give it away entirely. Licensing is like renting. You grant someone temporary permission to use the mark, but you still own it.
Okay, let's start with assignment, the full transfer. Are there different types?
Yes. The main one is a complete assignment with the associated goodwill.
Goodwill. What's that in this context?
Goodwill is the brand's reputation, the customer trust, the positive vibe it has built up. It's intrinsically linked to the trademark.
So you have to transfer that too.
Generally, yes.
Wow.
An assignment without goodwill, sometimes called an assignment in gross, is usually considered invalid because the mark, separated from its reputation, could mislead consumers. You can also have partial assignments for just some goods or services or conditional ones.
Why is transferring goodwill so critical?
Because the trademark represents that goodwill to consumers. If the mark goes to a new owner without the underlying quality or reputation it signifies, consumers could be deceived. The law frowns on that.
Right, protects the consumer. What are the formalities? How do you make an assignment official?
You need a written agreement signed by both sides, the assigner, seller, and assignee, buyer. And crucially, you must record that assignment document with the relevant trademark office, like the USPTO in the US or UIPO in the EU.
Recording it makes it public record.
Exactly. It puts everyone on notice about who the new owner is and helps prevent future ownership disputes.
Okay, that's assignment selling it off. What about licensing, just letting someone else use it?
Right. Licensing lets another party, the licensee, use your trademark on their stuff, while you, the licensor, keep ownership.
Are there different kinds of licenses?
Sure. An exclusive license means only that one licensee can use it, sometimes even restricting the owner. A non-exclusive license means you can grant licenses to multiple parties, and sometimes a licensee can sub-license it further to others if the agreement allows.
Seems flexible. Is there a catch? A key thing to watch out for when licensing?
Absolutely. The most critical aspect is quality control.
Quality control.
Yes, as a licensor, the owner, you must maintain control over the quality of the goods or services the licensee is offering under your mark. You have to ensure the brand still represents a consistent standard.
What happens if you don't?
If you fail to exercise adequate quality control, it's called naked licensing. And that's bad. It can actually invalidate your trademark because the mark no longer reliably signifies anything specific about quality or origin to consumers.
Naked licensing. Definitely sounds bad. Is there a famous case about this?
Yeah, the classic one is Don Donut Kobe v. Hart's Food Stores from way back in 1959. The court basically said, license your mark, fine. But you must control the quality or you risk abandoning your rights.
So even if you're just letting someone borrow the name, you're still responsible for what they do with it quality-wise.
Yeah.
Okay. What about when whole businesses get bought or sold? How do trademarks move then?
It depends on how the deal is structured. If it's a stock purchase buying the company shares, the company entity itself continues to own the trademarks, even though the company's ownership has changed. So a separate assignment might not be needed.
Well, what if it's not the whole company?
Right. If it's an asset purchase where the buyer specifically picks certain assets, including trademarks, then yes, you generally need a separate, formal, written assignment agreement to transfer those trademark rights. And again, that needs recording.
So buying a company doesn't automatically mean you get the trademarks perfectly transferred. You need to check the details of the deal and do the paperwork. What about doing this internationally? Any extra hurdles?
Oh, yes. International transfers add complexity. The Madrid Protocol can help record assignments and licenses in multiple countries through WIPO.
That's helpful.
But different countries still have their own specific rules. Some are stricter about transferring goodwill. Some might even need government approval for transfers involving foreign companies.
Sounds tricky. Any examples where this went wrong?
The Apple versus Purview case over the iPad trademark in China is a famous cautionary tale. Apple thought they had the global rights, but issues with properly recording the assignment in China led to a huge legal battle and a massive settlement payment.
Wow. So dotting the I's and crossing the E's locally is critical, even with international agreements. What kind of fights tend to break out specifically around trademark transfers?
Several types. Trademark squatting is a big one. Someone registers your mark in bad faith, hoping to sell it back to you.
That sounds infuriating.
It is. Disputes also happen over invalid transfers, maybe arguing goodwill wasn't properly included. And unclear licensing agreements are a common source of conflict disagreements over usage scope, quality control, payment, how to end the deal.
So clear contracts are vital. Okay, this is all about managing the rights. Now, our notes mention something called inter partes proceedings. What on earth are those?
Right, inter partes proceedings. Basically, these are formal legal disputes between two parties specifically about trademark rights, and they happen before the Trademark Trial and Appeal Board, or TTTAD.
TTB, that's part of the USPTO, right?
Yeah.
Not a regular court.
Exactly. It's an administrative board within the USPTO. These proceedings focus specifically on whether a mark should be registered or should remain registered. Not usually broader infringement issues. Those go to federal court.
So a special trademark court inside the trademark office, what kinds of cases do they hear?
4 main types. First is opposition. This happens before a mark is registered. After it's published in that official gazette we talked about, anyone who thinks they'll be harmed by the registration gets 30 days to oppose it.
On what grounds?
Common grounds are likelihood of confusion with their own mark, maybe arguing the new mark is just descriptive or generic, or that it would dilute a famous mark. The Nike versus Callaway golf case over the one mark is a good example of an opposition.
Okay, so opposition stops a mark before it gets registered. What if it's already registered and you think it shouldn't be?
That's where cancellation comes in. You can file a petition to cancel a registered trademark with the TTT after it's registered.
And the reasons.
Mm.
Similar.
Similar, yes, likelihood of confusion, genericness, but also things like the registration was obtained fraudulently or the mark has been abandoned through non-use. The scratch golf case involved canceling a registration based on prior rights.
Okay, opposition before, cancellation after. What else?
There's interference, though it's rarer now. This is when the USPTO itself might initiate a proceeding because two pending applications or an application and a registration are just too similar in conflict. The TTAB then figures out who has the earlier superior rights.
Like a head-to-head clash.
Sort of. The Apple ProView iPad mess in China had elements of this kind of conflict over who had rights. And the fourth type is concurrent use.
Concurrent use, using the same mark at the same time.
Yes, but usually in different geographic areas. This happens when different parties have been using similar marks, often unaware of each other initially, in separate regions. They can ask the TTTB to grant them registrations limited to their specific territories if it won't cause significant consumer confusion. The classic Burger King case involving a local Illinois restaurant with the same name is an example.
Okay, so these TTAB proceedings are the formal way to sort out registration disputes. If you get pulled into one, what's the process generally like?
It starts with a formal complaint, a notice of opposition or petition to cancel. The other side files an answer. Then there's a discovery phase, exchanging documents, information, maybe depositions.
Like a mini trial.
Kind of. After discovery, both sides submit written arguments and evidence. Hearings are possible, but less common than in court. Then, the TTAB issues a written decision.
And can you argue with the TTAB's decision?
Yes. The decision can be appealed to a federal court if one of the parties isn't happy with the outcome.
So it can still end up in the regular court system. Okay, let's shift now. What happens when someone just uses your registered trademark without permission? That's infringement, right? Plain and simple.
Exactly. Trademark infringement. It's governed mainly by the Lanham Act here in the U.S. It's basically using a mark that's the same or confusingly similar to yours in connection with goods or services in a way that's likely to confuse consumers about where things are coming from.
What do you actually need to prove to win an infringement case?
Generally, three key things. 1, you own a valid, protectable trademark. 2, the other party, the defendant, is using a mark that's identical or confusingly similar. And 3, their use is likely to cause confusion among consumers. Often includes showing the uses in commerce.
That phrase again, likelihood of confusion. It seems absolutely central. How do courts figure that out in infringement cases?
They use a set of factors, often called the Polaroid factors from a famous case. It's a framework.
Kinds of factors.
Things like how strong is your mark, how similar are the two marks look, sound, and meaning, how related are the products or services, is there evidence people are actually confused, how are the products sold or advertised, what was the defendant's intention, did they copy deliberately, how savvy are the customers.
So a whole checklist to weigh up.
Right. Courts weigh these factors based on the specific case. The Brookfield case involving Movie Buff is a good example of applying these online.
Are there different ways infringement can happen? Different types?
Yes, several types. Direct infringement is a straightforward one. They just use a confusing mark. Contributory infringement is when someone helps or enables another party to infringe, knowing what they're doing.
Like an online marketplace, maybe?
Potentially, yes. The Tiffany v. eBay case explored that, though eBay wasn't found liable there under the specific facts. Then there's initial interest confusion. That's when a similar mark initially confuses a customer and draws them in, even if they figure out the mistake before buying. And the most serious is trademark counterfeiting.
Fake goods.
Exactly. Intentionally using a fake mark that's basically identical to the real one. Think fake luxury bags. The Louis Vuitton cases often deal with this.
Counterfeiting sounds like a nightmare. If someone is accused of infringement, can they defend themselves? Are there legitimate excuses?
Yes, there are defenses. Fair use is a big one.
Fair use. How does that work for trademarks?
2 main types. Descriptive fair use is using a term descriptively to describe your own product, not as a brand name itself. Nominative fair use is using someone else's trademark to refer to their actual product, like in comparative advertising or news reporting. The KP permanent makeup case is an example of descriptive fair use.
Okay, well.
Parody. If the use is clearly a joke or satire commenting on the original mark and it's not likely to cause confusion, that can be a defense. Think of humorous t-shirts mocking famous logos. The Mattel case involving Barbie parodies touched on this.
Parody, right. Any others?
Latches. This is basically arguing the trademark owner waited too long to sue, and that delay unfairly harmed the defendant. It's about unreasonable delay. The Luxottica case looked at latches.
So even if the marks are similar, there might be a valid reason or defense. If the trademark owner does win an infringement lawsuit, what can they get from the court? What are the remedies?
Several possibilities. Most common is an injunction, a court order telling the infringer to stop using the mark.
Stop them in their tracks.
Right. They can also seek monetary damages. This could be compensation for their own losses or the infringer's profits. In really bad cases, like willful infringement, they might even get punitive damages. The Adidas v. Payless case had a huge damages award.
Ouch. Anything else?
The court can also order the destruction of the infringing goods, especially with counterfeits, to get them off the market for good.
Serious consequences. Okay, what about a slightly different situation? Someone using a really famous trademark but on totally unrelated products. That's not quite infringement, is it? That's dilution.
Exactly. Trademark dilution. It's a separate concept. Applies only to famous trademarks. And crucially, it doesn't require likelihood of confusion.
No confusion needed. So what does it protect?
It protects the distinctiveness and reputation of the famous mark itself. It stops uses that might weaken or tarnish the famous mark, even if nobody's confused about who made the product.
Yeah.
It's governed by federal law, the Federal Trademark Dilution Act.
So it's about protecting the uniqueness of brands like Nike or Coca-Cola, not just preventing knockoffs. What are the main ways a famous mark can be diluted?
Two main types: dilution by blurring and dilution by tarnishment.
Blurring and tarnishment. Explain those.
Blurring happens when the famous mark is used on unrelated goods, potentially weakening its unique association. Like if someone started selling Tiffany brand tires, it might make the name Tiffany less exclusively associated with luxury jewelry in consumers' minds. The Mr. Charbucks coffee case against Starbucks involved a blurring claim.
Okay, blurring weakens the connection. What's tarnishment?
Tarnishment is when the famous mark is linked to something unsavory, low quality, or offensive, harming the mark's reputation. The famous Victor's Little Secret case against Victoria's Secret was about tarnishment, although the law evolved slightly after that case regarding proof.
So tarnishment damages the brand's image. And this only applies to famous marks. How famous is famous enough?
Yes, it's a high standard. The mark has to be widely recognized by the general consuming public in the U.S. Courts look at things like advertising spend, sales volume, duration of use, geographical reach, actual public recognition. Think brands like Tiffany, Nike, Visa, Louis Vuitton. Those are generally considered famous.
Okay, household names. If a famous brand proves dilution, what remedies can they get? Is it the same as infringement?
The main remedy is usually an injunction to stop the diluting use. Monetary damages are possible, but typically only if the defendant willfully intended to trade on the famous mark's reputation or harm it. It's often harder to get damages than in infringement cases.
So mostly about stopping the use. Are there any exceptions? Times you can use a famous mark without diluting it?
Yes, there are defenses. Fair use applies here too, like using the mark for parody, criticism, commentary, news reporting. Comparative advertising is generally okay. The Chewy Vuitton dog toy case against Louis Vuitton found the parody use wasn't dilution. Non-commercial use is also usually exempt.
So jokes and news reports are generally safe. Okay. We keep coming back to likelihood of confusion. Our notes even have a whole section digging deeper into it. It really is the cornerstone, isn't it?
Absolutely fundamental. Yeah. It's the key test for infringement, a major factor in registration refusals, oppositions, cancellations. It's everywhere in trademark law. And the Supreme Court confirmed in the B&B hardware case that a TTTAP find on confusion can actually impact later court cases. So those TTIB decisions matter.
We mentioned initial interest confusion earlier. Are there other specific types of confusion courts look at?
Yes. Besides that initial confusion, there's reverse confusion.
Reverse confusion. What's that?
That's when a bigger, later company uses a mark similar to a smaller, earlier user's mark. The risk is consumers might think the small company is infringing on the big company's brand, which isn't fair. The Goodyear Bigfoot tire case involved arguments about this.
Ah, the big guy swamps the little guy's identity. Interesting. Any others?
Post-sale confusion. This happens after the purchase. Someone sees a fake designer bag on the street, for example. They might not have bought it, but seeing it could still confuse them about the brand's quality or exclusivity, potentially harming the real brand's image.
So confusion isn't just about the buyer at the moment of sale. What are the specific standards or guidelines used to assess this likelihood?
Well, USPTO examiners use the trademark examining guidelines. They look closely at how similar the marks are sight, sound, meaning overall impression, and how related the goods or services are. In court, as we said, it's the multifactorial test applied case by case.
And we talked about defenses like fair use and parity for infringement. How do they play into the confusion analysis specifically?
They're directly relevant. If a use is clearly descriptive fair use, using a term honestly to describe your own product, it's less likely to cause source confusion. If it's an obvious parody, consumers probably won't be confused into thinking it's the real brand. The Southbutt versus North Face example fits here. Showing there's no actual confusion in the market can also help argue against a likelihood of confusion.
And just to recap, if a court does find a likelihood of confusion, remedies are
The main ones: injunction to stop the use, monetary damages, maybe even a product recall in some cases, like the Levi Strauss pocket tag case.
really highlights why picking a unique mark and doing that initial search is so crucial. Okay, our notes also give an overview of trademark claims and litigation,
Yeah.
focusing on some real-world examples from India. That sounds interesting.
Yeah, looking at how these principles play out in different countries is really valuable, especially today. In India, like most places, claims usually center on unauthorized use, likelihood of confusion, or dilution of well-known marks.
And there are some specific Indian cases that really illustrate these points.
Definitely. There's Parlour product VJP & Co. about similar packaging confusion even way back. Yahoo via Kaush Arora was an early important cybersquatting case. Mahindra and Mahindra v. Indigo Airlines recently showed a company proactively changing branding to avoid a dispute.
Proactive moves. Smart.
Right. Burger King Core v. Burger King Poon dealt with prior local use rights. ANI v. Netflix touched on using content and trademarks in streaming. Lacoste versus Suresh Kumar was a long battle over a famous logo. And Dr. Reddy's Labs versus Fast Cure Pharma highlighted the need for clear distinctions with pharmaceutical marks very important for safety.
Those really bring the concepts to life. What remedies are typically available in India if infringement is proven? Similar to the US.
Generally similar, yes. Injunctions are key, stopping the infringing activity. Monetary damages for the owner's losses. An account of profits where the infringer has to give up the money they made unfairly. And delivery up handing over the fake goods for destruction.
And what factors do Indian courts weigh heavily in these cases?
Evidence of the plaintiff's own use and reputation is vital. Proving consumer confusion is, of course, usually central. Jurisdiction which court can hear the case is important. And acting promptly matters. Delaying too long can weaken a claim.
It really seems like the core ideas protect identity, prevent confusion, are pretty universal, even if the legal systems differ slightly. Which brings us nicely to our last big section, International Trademark Law Overview. How do businesses protect marks globally in this interconnected world?
Yeah, it's critical but can be complex. Luckily, there are international treaties designed to help streamline things.
We mentioned the Paris Convention earlier.
Yeah.
What are its main takeaways again?
Key things from Paris Convention. National treatment foreigners get the same rights as locals in member countries. And the right of priority, that 6-month window to file in other countries and keep your original filing date. Foundational stuff.
And the Madrid system, you said that was more efficient. How exactly does it work?
Right, the Madrid system, run by WIPO. You start with a basic application or registration in your home country, if it's a member. Then you file one international application through your home office, designating the other Madrid member countries where you want protection.
One application for multiple countries.
Yes. WIPO checks it formally, records it, and tells the designated countries. Then each country examines it under its own national law. They can still refuse it for their territory, but if approved, you get protection there. And managing renewals is centralized too. It simplifies the portfolio management.
Sounds much better than filing everywhere separately. What about the TRIPS agreement? That's linked to the WTO.
Yes, TRIPS is trade-related aspects of intellectual property rights. It sets minimum standards for IP protection, including trademarks that all WTO members must follow in their national laws.
Minimum standards like what?
For trademarks, things like protecting service marks, requiring initial protection for at least 7 years, renewable indefinitely, and mandating effective enforcement measures, including border controls against counterfeits.
And within Europe, there's the EUTM.
Right, the European Union trademark. One registration through the EUIPO office gives you unitary protection across all current and future EU member states. Very efficient if your market is primarily the EU.
So several systems to potentially use depending on your scope. Any interesting recent international cases that show current trends or challenges?
Definitely. That Sky v. Skykit case in the UK really dug into bad faith filings, registering for things you don't intend to use. Has big implications. The James Bond case in Austria reinforced the use it or lose it principle, leading to partial cancellation for non-use. And the Mahindra Indigo case we mentioned shows how these conflicts can span industries globally.
These cases show the law is constantly being tested and refined. What are the biggest ongoing challenges internationally right now?
Counterfeiting is still a massive problem fueled by global trade and e-commerce. Digital infringement on websites, social media is exploding and hard to police. And then there are new frontiers, protecting non-traditional marks like sounds or smells and figuring out how things like NFTs or AI-generated brands fit into existing laws. That's a big question mark.
AI creating brands. Definitely a future headache or opportunity, depending on how you look at it. So pulling it all together, what are the key takeaways for navigating international trademark protection?
Okay, key points. Use the Madrid system if possible for efficiency. Understand the TRIPS minimum standards. Consider the EUTM for EU coverage. Be aware of the increasing focus on bad faith and the use it or lose it requirement globally. And stay vigilant about digital infringement and be ready for challenges from new tech like AI.
It certainly sounds like a dynamic field. Well, we have definitely done a deep dive today into the whole world of trademarks, from that first idea to protecting it across borders. It's so clear that understanding this stuff is absolutely essential for anyone building a brand today.
Absolutely. And